Carmelo Anthony's new team of high-powered lawyers are going scorched earth on the judge who oversaw the team's trial that ended with him being convicted of murdering fellow athlete Austin Metcalf.
Case file number 1, Collin County, Texas. A single stab wound, 1 inch wide, delivered under a team tent at a high school track meet. That's the entire physical record of how Austin Metcalf died. No premeditation charge. No prior altercation on paper. Just one wound, one knife, and one 18-year-old holding it when the ambulance arrived. Now picture that scene frozen. The tent poles, the stopwatch still running on a nearby table, a track meet that never finished. That single frozen frame is the whole case. Everything the jury saw, everything the appeals lawyers are now fighting over, traces back to those few seconds under canvas. Before we go further, this is the Dark Discovery Files, and if you're new here, this is exactly the kind of case we specialize in. Not sensational retellings, but the paper trail. Court filings, verdicts, motions, the parts of a case that don't make it into a 30-second clip. Subscribe if you want cases built strictly from the record, because what happened after the Metcalf verdict is a masterclass in how a courtroom can follow every rule on paper and still leave a defense team convinced the process failed. Here's the official version, the one that closed with a guilty verdict inside of 3 hours of jury deliberation. In April, at a track meet outside Dallas, Austin Metcalf confronted Carmelo Anthony, who was reportedly standing under the Metcalf team's tent.
This is the body cam video from one of the first officers who confronted Carmelo Anthony after Austin Metcalf was fatally stabbed. Anthony stabbed the fellow track star during a high school track meet in April of last year outside Dallas in Frisco, Texas. Now, here is the very blurry video of the incident. It was shot from a surveillance camera on the top of the football stadium. It shows some commotion, shows a potential shove from Austin Metcalf, but the moment in question, the stabbing of Austin Metcalf, is something you really cannot see. But this surveillance video was big evidence at the trial. Anthony was reportedly under Metcalf's team's tent. Metcalf wanted Anthony to leave. Anthony did not leave, and then Metcalf shoved Anthony, and in that moment, Anthony pulled a knife out of his...
Words were exchanged. According to trial testimony, Metcalf shoved Anthony. In that instant, Anthony pulled a knife from his backpack and stabbed Metcalf once in the chest. A grainy stadium surveillance camera caught motion, a shove, a scuffle, but not the fatal moment itself. That gap in the footage, the second the case actually turned on, was never recorded by any camera anywhere. The jury filled that gap with testimony. 3 hours later, they returned a murder conviction.
Guilty verdict. In the days after the verdict, Carmelo Anthony filed a notice that he would be appealing the verdict, and these filings appear to be the first step in that process. Now, there were 2 documents that were filed. One is calling for a new trial. The other calls for the judge who oversaw the trial to be recused from any future proceedings on this case. So I want to start with why.
That's the closed case. Here's the part that isn't closed. In the weeks after sentencing, a new legal team, 6 attorneys organized under a coalition calling itself Stand with Carmelo, filed roughly 200 pages in Collin County Court. 2 documents, specifically, a motion for a new trial and a motion to recuse the presiding judge, John Roach, from any further proceedings. Neither motion argues Anthony is innocent. Both argue the trial itself was broken before the jury ever left the room. So ask yourself this. If a courtroom follows every written rule and still produces a result one side calls unfair, where exactly did it go wrong? And can you even find that failure in an official transcript? Or does it only show up in what got left out? The first claim in the filing is about the room itself.
Believes that Carmelo's guilty verdict should be tossed. Anthony's lawyers are arguing that his 6th Amendment right to a public trial was violated. They say that this case received national attention, and yet the proceedings, they argue, were kept out of public view. Audio and video recordings were not allowed. We couldn't live stream it. We were only getting reports from a small number of credentialed media members.
Judge Roach barred cameras. He barred audio recording. He barred live streaming. For a case that had already drawn national attention, that meant the only real-time record of the proceedings existed in the memory of a couple dozen credentialed reporters physically inside the courtroom, law and crime among them. The gallery held roughly 24 public seats. Court records and courtroom observers describe lines forming outside daily. People who reportedly traveled from other states hoping to witness a case they'd followed for months turned away at the door. An overflow room that had existed earlier in the proceedings was, according to the defense filing, eliminated before the trial concluded. The appeals team frames this as a Sixth Amendment problem, the constitutional guarantee of a public trial, and argues that a courtroom the public physically cannot enter isn't public in any meaningful sense, whatever the seating chart says.
The verdict.
I'm doing this interview with you to make sure that people understand how the system works. And if they really wanted to, and I mean this seriously, if they wanted to, they could have stood in line with everybody else.
When the public can't watch, the record protects the process, not necessarily the truth. That's the first turn in this case, and it's worth sitting with, because it's not really about cameras. It's about whether open court can survive becoming, in practice, a room almost nobody can get into. The second claim is where the case gets genuinely strange, and it centers on a decision that never appears on any docket. The decision not to put Carmelo Anthony on the stand. In a self-defense case, a defendant's own testimony is often the centerpiece of the entire defense. Anthony never testified. According to the new filing, that wasn't a straightforward strategic call made over the course of the trial. It was the collapse of an informal understanding between the prosecution and the original defense team, reached by phone weeks before trial, and never entered into the court record.
To Anthony's new team, a lot of it had to do with what they say was an off-the-record understanding between the defense and prosecution. So this is what it says. Anthony's appeals team said in May of this year, the lead prosecutor on the case reached out to the defense and proposed they, quote, try the case clean. And that would mean they would make this case only about what happened under the tent instead of offering character or reputation evidence. Now, that deal was off the record. And they say the reason for that was so the media wouldn't get word about it because it's probably something we would see in court filings.
The defense's account describes an agreement to keep the case narrow, limited to what happened under that tent, with no character evidence, no reputation testimony, introduced by either side. Because it was never filed or read into the record, there is, by the defense's own admission, no official document proving it existed at all. Here's the ticking clock moment, the one the entire appeal turns on. If that unwritten understanding existed, it meant the original defense chose not to introduce statements other witnesses reportedly gave police. Descriptions characterizing Metcalf as combative, quick to anger, protective of his twin brother to the point of confrontation. It meant no expert testimony on how Anthony's epilepsy might have affected his perception of threat in that moment, and none on adolescent brain development. Relevant, the defense argues, because Anthony was 18.
It reports. Now, Anthony's team says that his defense was then limited under that deal at every stage of the trial. They say the defense could have presented statements that trial witnesses made to police, like saying that Austin Metcalf was, quote, kind of like the aggressive guy on the team. They say that there's a student who told police that Austin would get, quote, triggered. And they also say that there's a witness who told police that Austin and his twin brother Hunter refused to be disrespected. They also say under this off-the-record agreement, the defense didn't bring any expert witnesses who could have talked about how Carmelo Anthony's epilepsy could have impacted his perception of threat, or how the fact that he has an adolescent brain, he was only 18 years old when all of this happened, how his brain wasn't fully developed, and that may have impacted his ability.
And then, according to the filing, on the second to last day of trial, the day before Anthony was expected to testify, prosecutors reportedly said the agreement never covered a testifying defendant, and that the defense had already opened the door to character evidence in its opening statement by mentioning that Anthony liked to play chess. The defense claims a 19-year-old was then given 10 minutes to decide whether to waive his Fifth Amendment right and take the stand in a murder trial. 10 minutes. If that timeline is accurate, ask yourself what any defendant, regardless of guilt or innocence, could reasonably weigh in that window, and what a jury never got to hear because of it. There's no written contract, no recorded phone call, nothing beyond both sides' word for what was agreed and when it allegedly broke down. That absence is the entire fight. The prosecution's position, as characterized in the filing itself, is that no such formal deal ever bound them regarding a testifying defendant. The defense says the informal understanding shaped every decision they made in the run-up to trial, including the one decision that arguably mattered most. A trial without a paper trail leaves no way to prove what was promised, only what was lost. That's the second turn. The third claim shifts the target from the trial itself to the man who ran it. In the days following the verdict, before sentencing, before the 30-day window to file post-trial motions had closed, Judge Roach gave an on-camera interview to a local television station. Asked whether the jury got it right, he said, in substance, that they had, because they were seated properly, weighed the facts presented in his courtroom, and reached their verdict through the process.
Did the jury get it right?
Yeah, they did. You know why? Because they were picked based upon the law. They listened to the facts that happened here in this very courtroom, and they got a verdict. And so that's the process, and whatever they say.
He also posted a public letter on the county website thanking those involved in the trial for conducting it, in his words, fairly and with dignity. Standard language for closing out a difficult case, on its face. The recusal motion reads it differently. The defense argues that a sitting judge publicly affirming a verdict, while post-trial motions in that exact case remained legally available and still pending, created an appearance of bias no future ruling from that same judge could shake. It's a narrow, technical argument, and it's also a fair question worth asking on its own. Can a judge who's told a television camera the jury got it right still be seen as neutral when he's the one deciding whether that same verdict deserves a second look? The filing doesn't accuse Roach of misconduct during trial. It argues the interview itself, timed where it was, undermined the appearance of impartiality the post-conviction process depends on. A judge who declares a verdict correct in public has already ruled on the appeal he hasn't heard yet. That's the third turn, and it's the cleanest version of the pattern running through all 200 pages. A process that was legally sound on paper and, according to the people now contesting it, compromised everywhere paper couldn't reach. So where does this actually go? Under Texas procedure, the recusal motion moves first.
Well, the next step is the ruling on the judge's recusal. So he can voluntarily recuse himself if that's what he so chooses to do, and then it'll be assigned to another judge in Collin County. If he does not recuse himself, then it has to be forwarded to another judge who will then have a hearing on the merits. And then the judge will determine based off of that hearing if it is something that needs to go to another judge to be ruled on. And if so, another judge again will be determined to be the person who makes the rulings on the procedures going forward in the case. Now, is this something that happens tomorrow or the next day? I don't know yet. Probably not. But these things in our legal system can sometimes take a little.
Judge Roach can step aside voluntarily. If he declines, the matter is forwarded to another judge for a hearing on the merits, who then rules on whether Roach should be removed from further proceedings in the case. Only after that gets resolved does the motion for a new trial move forward, reviewed first at the trial court level, where a judge examines whether legal error, new evidence, or procedural irregularity affected the fairness of the proceedings. If that motion is denied, the case can be escalated to a state appellate court, and that stage, the one that actually has the power to overturn a conviction, is typically measured in years, not months. Ineffective assistance of counsel claims, which is the underlying legal theory behind much of this filing, carry one of the highest bars in American appellate law. It's not enough to show a different choice existed. The defense has to show that a different choice would have changed the outcome. That's an exceptionally difficult standard to clear, and nothing here in the record so far shows it has been.
Well, the ineffective assistance of counsel claim by an attorney, it's a high threshold for someone to reach. And what it's deemed to be is that if the attorney had done something differently, if they had presented this evidence, if they had done these things, then the outcome would have been different. They have to show that the outcome would have been different if the attorney had done those things. And so is it a concern? Is it something that could be raised? Possibly. Do we know that it would make it to the point of we know that the outcome would have been different if those things had been presented? We don't know.
None of this changes the fact that a jury heard 4 days of testimony and returned a unanimous guilty verdict in 3 hours. None of it argues Austin Metcalf's death was anything other than what the jury found it to be. What it argues, and this is a claim, not an established fact, filed by one side and formally contested by the other, is that the machinery around that verdict, the closed courtroom, the unrecorded agreement, the 10-minute window, the judge's own public words, may not hold up to the scrutiny an appellate court is now being asked to apply. Because here's the uncomfortable question underneath all 200 pages, the one that has nothing to do with which side you believe. How much of what actually decides a criminal trial? Real trials, not just this one, happen somewhere a transcript never reaches? A phone call between opposing counsel, a 10-minute conversation in a holding room, a closed courtroom door. If the answer is more than we'd like to think, then the real story here was never really about one stabbing under one tent. It's about how much of the justice system runs on trust nobody wrote down. The full text of both filings, the motion for new trial and the motion to recuse, is part of the public record in Collin County, Texas, and it's worth reading in full rather than taking any single summary's word for it, this one included. Go find it. Read what the defense actually claims, and read how the prosecution has responded where responses are on record. Then decide for yourself. Was the trial that convicted Carmelo Anthony fair because it followed procedure, or unfair because procedure left too much room for things that were never written down? Tell us what you think in the comments. We read everyone. If this case raised more questions for you than it answered, that's exactly the kind of file we build episodes around here at the Dark Discovery Files. Like this video if you want more cases broken down strictly from court documents and public record. Share it with someone who'd rather see the paperwork than the headline. Subscribe if you haven't already, and turn on notifications, because the next file is already open.